To be a public defender, at the heart of it, you really have to care about people and be willing to fight for people, and not just fight, but give it your all. And in giving your all, remember that it's not about you.
Howdy, and welcome to the show. Cooper's Code focuses on legal issues and notable practitioners, distilling wisdom so we all achieve the best results for our clients. I'm Miles Cooper, and I'm thrilled to share part 3 of this conversation with Phoenix Streets. How long were you in the felony trial unit?
20 years.
Was there a point at which you eventually work on the homicide and sex crimes cases?
Yes, it took only about a couple of years, maybe 2 years before I started getting sex cases and assigned the homicide case.
Anything different in terms of how you approached those cases from, say, the prior felony or prior misdemeanor cases, or is a case a case a case?
Pretty much to me, a case is a case is a case. It's the same fundamentals. Got to get to know the clients. Got to do the research. Got to make sure the investigation is done. You got to look closely at the evidence because you want the best outcome no matter what type of case it is. Mind you, some cases take more effort than others. Because more resources involved because there are more facts or witnesses, evidence to deal with. That's what really is the difference between the cases. Is what is the evidence? So, of course, a homicide, you're looking at, you have to look at more than just the charge and the potential outcome, which in fact is a thing that paralyzes some people. Is just the fear of the potential outcome.
Paralyzes the lawyer, paralyzes the client?
The lawyer. That fear of, if I get this wrong, it's going to just be over for this person. Their lives over, and they can't get past that thought. That fear is healthy. You need to have that fear. You need to be concerned that if you make a mistake, that it could cost this person everything. So that fear can be a motivating factor in you making sure that you do the work that you need to do, that you dot your I's and you cross your T's, so to speak, that you make sure that you get it right. But for some people, that fear, rather than being something that motivates them to do better, it freezes them. And so they become so afraid that they do make mistakes.
Do you find that is something that happens at levels? And here, my hand is going up as we're having this conversation.
Yes.
For some people, the fear doesn't necessarily grip them when they're in misdemeanors, but when they get advanced to a different type of a case, it starts to overwhelm them.
Exactly. Yes. I just said even that transition from misdemeanor to felonies, going from jail time to potential prison time, or from working on a non-sex case to a sex case, knowing that if the person is charged with a sexual offense, if they are found guilty, even if it's a misdemeanor, some misdemeanors, they're not going to do a bunch of time in custody, but they will be branded with the sexual registration. And that can have devastating consequences for somebody's life. It affects where they can and cannot live. Nobody's going to want to hire somebody with the sex reg. It's a life sentence. They're not in prison, they're not in jail, but they're ostracized.
When you have encountered this, what tends to happen to that kind of a defender? Do they exit the defender's office at that point? Do they get moved back to the prior caseload? What are the solutions, or are they coached up? What tools exist for someone like that?
A lot of times they leave because this work isn't for everybody. In fact, I would say it's not for most people. So they leave, or we talk, counsel and explain that that fear that you have is understandable, it's normal, and you should have it, and there's nothing wrong with that fear. It's just how you use it. So can you use it as a way to motivate you rather than freeze you? Can you break out of that? And that's a question really for them that you're asking them for themselves. And if they, after thinking about it and reflecting upon it, decide that, yes, I can use this as something to motivate me to be the best that I can every time, then yes, then they stick around.
Did you hit that friction point at any point in your career where that issue came up for you?
Not in a way that it paralyzed me. It has happened that that I had some self-doubt, that am I really up to this? I'm tired. I've been going on for a while. Is this really something I can take on? And that's when I lean on my colleagues, because we're not in it alone. I'm not in it alone. I have people that I can turn to. And that's one of the great things about being in the public defender's office is that we rely on one another, and we're like family. I mean, like family. You know how families are. You don't always get along. You don't always agree. There are some shouting.
With all the dysfunction that sometimes comes with that phrase.
Exactly. With all the dysfunction that comes with that phrase. And yes, I have my fears. I have my fears. But with the public defender family and the people, really good friends in the office that I can lean on and we could talk to and commiserate. I mean, we laugh and we cry together. And with those people and those shoulders to cry on, to lean on, to hold us up, I have been able to keep going.
When I think of people who have challenging professions in terms of seeing loss, oncology would be one where a certain number of your people, no matter how hard you try, you're not going to keep them. And I would think in the public defender's office, particularly in felony cases, there are going to be people who, no matter how hard you fight for and how strongly you believe in the case, it doesn't turn out the way you would like it to be. Are there ways that you have found beyond your colleagues, your family, to be able to handle that level of stress, of challenge in your life?
For me, it goes back to remembering what makes me happy. And this is true for my colleagues, is never forget the things that make you happy. And so when things are at their darkest and you're at your most stressed, why don't you do that? Why don't you go back, take a little break? You have to take breaks. You definitely, in this job, breaks are very important. If you like riding bikes, ride that bike. Exercise is very important. So whatever you do for exercise, it doesn't have to be strenuous. Like I'm a big fan of walking. I walk around. You'll see me walking around the city all the time. Walk. If you like dancing, dance. Like listen to music, listen to your music. Do those things that make you happy. Take a break to get away from the stress and sometimes very bleak nature of what we do and really tough outcomes. Because like I said, I mean, I've had cases that didn't go the way I thought they were going to go, and was shocked by a verdict that just couldn't believe. So yeah, I mean, so you got to get out. It's good to take a break away from the situation, away from the cases, away from the case, away from the office, and do the things that make you happy and bring you back to yourself. Because a lot of this job is about giving of yourself. You have to give that energy that you have. It goes into the work, your energy, the physical energy, the mental energy, and the emotional energy. And it's not easy to regulate all those things. And if you don't, you're going to find yourself breaking down. And sometimes you will. That's just the way it goes. I mean, tell you, one of my first trials, during the closing argument, I started crying. I was embarrassed about it because, I'm trying to be the tough professional, but it really got to me. And, but hey, I'm human. But yeah, so yeah, it's important to take a break. And otherwise you're going to crack.
Trial moments like that where emotion overcomes you. How did you handle that?
I just paused. It was, of course, it was during a closing argument. So I was talking, of course. So I just paused for a moment to gather myself. And I was hoping that it happened really fast and so quickly that nobody noticed that I started crying, was just pausing, and went back. After I gathered myself, just started up again.
Did you get any juror feedback after that? Did they notice?
I'm sure they noticed, but they didn't. They didn't say anything about it. The feedback about the crying came from my colleagues.
What was their feedback on that?
Their feedback it wasn't negative. It was that it seemed like a real, and it was a sincere moment. I haven't seen it myself, but I've heard about some of my other colleagues who have cried during a closing argument, and it looked completely forced and phony. And you never want to appear to be phony or fake in front of a jury.
Yeah, I've been told that people believe that faking emotion is one of the things that is taught in law school.
Well, if they knew anything about law school, they know they teach you to have no emotion in law school.
True enough. As we talk about trial moments, are there trials you've had or moments you've had, either Perry Mason highs or lows, that you feel would be appropriate to share?
I can think of one off the top of my head about an example of how you don't know everything. I had this case. Client is charged with going into a parking lot and breaking into a car. And it seemed like a pretty open shut case. There was a security guard who saw the whole thing, walked up to the client. The client was in the car going through the glove compartment. And so I'm talking to the client. We're in court about, potentially a plea agreement. And he's like, "No, I'm not pleading anything." I'm like, "What?" He's, "No, I wasn't trying to steal anything. I was just trying to, the car window was rolled down, and I was trying to get the contact information for the owner of the car so I could contact them." And I'm like, nobody's going to believe that. And he's like, "Yeah, that's the truth." I'm like, "Are you sure?" I'm like, "Okay, so we'll go with it." We go to trial. He testifies, not guilty.
Wow.
The big lesson that taught me is that it's also, for jurors, it's the likability and believability. If they like your client, they're more likely to rule or find a verdict in the client's favor if they like them. But the other thing is true too. If they don't like your client, they're looking for a reason to convict.
So that leads to a question about whether your clients testify or don't testify, and how you make a decision on that. Because I understand that in the criminal realm can be a controversial decision in a case. How do you approach that? What considerations do you have in terms of making a decision about whether your client testifies?
So for me, I approach it with my general idea. My general rule is client will testify if they can. If they can, it's always better for the client to testify because the jurors want to hear the client testify. So if my client can, because not everybody can testify because of reasons like they're unlikable, they're really shy, they'll freeze up, they can't really express themselves, or the DA is just going to rip them up. Those reasons. So if my client can, I prefer that they testify. But the decision is up to them. So I will talk to the client and see what they want to do. And that's a conversation, that's an ongoing conversation, even up until the point that we're in trial and it's time for them to testify. So it's an ongoing conversation that we'll have. And we'll do mock, direct, and cross. So I'll do the direct and initially I'll do the cross, but then I'll have somebody else come in and do a cross examination. And these mock cross examinations are not friendly cross examinations. A lot of times they're going to be harder cross examinations than what is actually going to happen to them in court with the prosecutor.
Do you have people in your office who are seen as good people to play the role of particular prosecutors?
Not necessarily particular prosecutors. We always try to do better or harder than that they would do it.
As you talk about mock trials, the other question that comes to mind in the civil side, there oftentimes are focus groups or mock trials that will be done with a panel to evaluate, provide thematic feedback. Is that something that the budget for the public defender's office allows in say, particularly high-profile cases, or is that non-existent?
It's existent, but I've only heard that being done less than a handful of times.
Any other cases or moments that you'd like to share with us?
I had a trial. This is a sex case. Initially, it started off client accused of imitating a police officer. It was 2 alleged victims, one that they never found, and another, the one that they did was, let's say, not a good historian of what had occurred. So, pretty simple case. The district attorney put out a press release, and then suddenly there were 5 other victims. So suddenly the case is now becoming complicated. And with the press release, it's asking them to come forward and letting them know that there are resources available. So now we got, okay, well, are these people really victims, or are they coming in to get a lot of these folks, well, everybody were, except for a client, recent immigrants and young men in their early 20s. And client, well, this case became really complicated. In the end, after all the witnesses had testified, after we did closing arguments and the jurors were deliberating, client said he wanted to talk to the judge. I said, what do you want to talk to him about? And he said, testifying. I was like, well, it's too late for that. You'd already said you didn't want to testify. We're done. He insisted on speaking to the judge. Okay, speak to the judge. And so he told the judge that I never informed him of his right to testify. Mind you, we had done a number of mock cross-examinations for him. And each time it was bad because he just couldn't keep his story straight. And it changed every time. And each time it was more unbelievable. I'm like, that's a bad idea. And so anyway, so he tells the judge that. And I informed the judge, no, I informed him, and he decided not to. And so the judge said, okay, well, we need to have a hearing. And so we have the hearing, which is really weird. So now I'm in the position of having to testify against my client regarding this. And in the end, I said to the judge, like, I informed him I was right. And we had to bring in witnesses, which were the people who cross-examined him. And I told him he could testify. I think it's a bad idea, but he could testify. And the judge was like, well, I want to know, can I have him testify? Yeah, can he? I'm like, yes, you have. He said, well, okay, well, I want you to bring me back the law on that. So we come back, show him the law, and of course, he asked client, he said, you can testify now. So we put him up on the stand. He gave this unbelievable story, including that the witnesses the victims weren't his type defense. And in describing his type, he was looking at my intern. And my intern was a girl, and he's gay. So we do another closing examination. We do another closing argument. Jurors come out with a note. Can we have new verdict forms? Which I already know what that means. They already had verdicts. And that from our first closing examination or closing arguments. And so now they're going to find him guilty. Well, they're going to find him guilty. They're going to rip up the not guilties. And that's exactly what happened. And after his testimony, he said, how did I do? And I said, you did as well as I thought you would do. And so they found him guilty on all counts.
And what you're saying is they needed the new verdict form because they had found him not guilty, and now he had gotten himself, I think the line is, defeat from the jaws of victory.
Exactly.
Yeah.
And I asked the jurors about it afterwards. I'm like, well, what did you think about his testimony? And one of the jurors said, besides watching you grimace, which I thought I had the straight face. And he said, well, the airlog, he did himself no favors by testifying. So that was a very strange experience for me to have a client do that and have to testify against a client and then have to have him, testify knowing that he was up there not telling the truth and how to ask questions in a way that I'm not getting him to perjure himself on the stand. And so it was basically just let him tell his story, and I didn't really ask many questions. So, and the judge let it, most of the time, if any other case, the DA would object. In this case, he did, saying it's a narrative. Judge overruled and just let him testify. And even after that, still being the advocate and still trying to fight hard and to make sure that even though I knew that, that he had already sunk his own battleship, to try to do the best I can and stay professional and not take it personal.
It's a hard day in court.
Very hard day in court. That was definitely one of my hardest jury trials. I mean, it was harder, it was very difficult even before that, going through, because each witness, each complaining witness, each victim was like a trial in and of itself. Because they each happened on different days within the same time period, year. And they didn't know each other. And so for each witness, I had to prepare. It was like a different trial. So trials within trials. And then to have this happen at the end of the trial or towards the end of the trial made it even more difficult. And I was concerned about whether or not I could continue to represent him at this point in the trial when he did that. Because it did feel personal that he would tell the judge that I did not tell him about his ability or his right to testify. And then me having to put on witnesses and essentially testify against him. In fact, I was so concerned that I went to the number 2, Matt Gonzalez, and expressed my concern as to whether or not I should remain on the case and perhaps it should be reassigned and have a mistrial declared. But he convinced me that, no, I should stay on Really how, if I feel that I can do it, and if I can feel that I can still do my job and not take it as such a personal affront that I just want this guy to go down. And so after a bit of soul searching, I decided, well, I can still do my job. I'm still a professional. And what I do is not simply for him, is more about the principle and the philosophy of being a public defender and the belief that everybody has a right to zealous representation, regardless of what my personal feelings may be for the particular person. Because, I'm not going to like everybody.
More recently, you have switched into a different role with the Defender's Office. Is that correct?
Yes, I am now with the mental health unit, which is a very small unit. There are 3 attorneys, and we have over 700 clients. We represent people who are either being conserved or are already conserved. We also represent people who have been found not guilty by reason of insanity, and they're in either the state hospital where they've been released to step down. We call it step down to lesser restrictive place. It could be in the group home, or they could be in independent living environments. We also represent people who have been found incompetent.
Have you been enjoying that work?
It's funny that question, enjoy work, but yes, I find it's somewhat the same because it's still dealing with people's liberty, but it's a completely new area of law for me. I am enjoying it, and every day it's a new challenge, never boring. But it's challenging because a lot of the clients are very seriously mentally ill. We've had people who have been in placements for over 20 years. And some of them are going to be in it the rest of their lives. And so, as of where I was doing on the criminal side, I'd represent a person for a particular length of time, but it's not going to be that long. Maybe a year or 2, but that's it. Once the case is done, we part ways. But in my job now, I'll be with people for years, probably the rest of my career. And another different thing about it is we have hearings because there's probable cause hearings in hospitals. And so mainly San Francisco General, where the doctors want to keep them for either a couple of weeks, or a month longer against their will, because the doctors believe that they'd be unable to survive on their own if they're released out into the street because they are in such mental distress. Also hearings at the hospital regarding whether or not they should be forced to take psychotropic medications to bring them back to a level of mental stability that they can survive if they're released. Or, keep them a little longer and if they can't, they'll be conserved.
Is there a parallel unit with the district attorney's office that is your opposition on cases like this, or is it more of a holistic approach to what's going on?
The district attorney's office represents, they do people who are, if the client has been found not guilty by reason of insanity, that is something that the district attorney will do. But the LPSs, we call them, that's the short term. For the conservatorships, Letterman-Pinterest Short Act.
Okay. I wondered what it stood for.
So that's they're represented by the city attorney's office handles those for the office of the public conservator, which is under the Department of Aging. So apparently there was a time where the district attorney did that, but they don't do that anymore.
As you look back on where you are now with your career with the public defenders, is there anything, if people were wanting to be a defender or are in the process with their career, is there anything that you feel you would have done differently or wish you would have known as along the way?
I think that the one thing I know that I came in is like I can relate to people, especially our clients, because of my background. But to be able to tell their story in a way that others can understand and be able to relate to, that took time. I would have liked to have had that, the experience and the training to have known that, before. And also how to speak to judges. That is something that has taken a while. In my time when I first started, I just saw judges, politicians in robes. I still think that, but I think more. They're still people, and they have their biases, just like everybody else. And they also have, people think of biases as negative things. They aren't always necessarily negative. For example, I was a judge that I knew that I learned that she was always concerned about welfare of children. And so if there was a child involved, she would really be focused on that. And if it was a client who had a child, she'd want to make sure the child was taken care of. And so she wouldn't want to penalize the client in a way that would make it bad for the child. But that's not even it yet. The thing that I really wish that I knew then, or that I know now, is how tough it can really be emotionally. How you can't just put your emotions, or you can't just push them down and out. And how they're always there for each case. And that you have to prepare yourself for that, for the emotional nature of the job and the cases, that you really can't just go in there without considering the emotional effect that it can have on you as a personal. Of course, it's going to be emotional and of course, remember that it's going to be emotional for more. If it's emotional for you, imagine how emotional it is for the client. But when you really feel for your client and you really feel the pain, and it's a cumulative effect. You have one client, you feel for that client, that emotion doesn't go away. It's still in you. And whatever happened with that case. And we deal with a lot of people who are in pain and who are suffering, and see it every day. And it builds up. And to know that and to be able to deal with that so that it doesn't eat me up inside, that is something that I wish I'd have known and been able to prepare for at the very beginning.
On behalf of someone who didn't take that path and hears how challenging that is and knows how many decades you've put into it, thank you for devoting your career to that level of service. I have to imagine you've left a lot of yourself, poured a lot of yourself into what you do.
My colleague, Jaku Wilson, and I, we joke about this because, a lot of times we'll be in the office early in the morning, late at night. So, I'd say working from can't see in the morning to can't see at night. And as tough and as painful and as emotional as it is for us, he's also African American. Just imagine what it was like for the slaves, for those who came before. And look at us now. And that's hope.
It is.
I am living good.
Anything else you want to bring forward for our listeners?
To be a public defender, at the heart of it, you really have to care about people and be willing to fight for people, and not just fight, but give it your all. And in giving your all, remember that it's not about you.
Well, thank you very much, Phoenix. I really appreciate you taking the time today.
Thank you for your time.
And thank you for listening today. Please email us at podcast@coopers.law with questions, comments, feedback, and suggestions for who we should have on the show. Like what you heard? Share us with a colleague and leave us a 5-star review on your podcast platform of choice. To all of you doing justice out there, happy hunting.